So vetting has just started. The meeting has been called to order in session. There are two more of the justices of the Supreme Court who are going to be vetted today. The first is Justice Hafisata Amaleboba, who is also a Court of Appeal judge. She's taking her turn the first time. After her would have later in the day Justice Kweku Akabuafo. You know, one thing about these two nominated justices is that both of them have sat on some controversial cases in the past, and so the expectation is that some questionings in regards to some of their judgment and some of the cases they've sat on would be, featured during their vetting. And that of the first, who is the second of the two women appointed by the president, Justice Hafisata Amaleboba, for instance, she sat on the famous or controversial case Jan versus Jan, that popular case that involved Asamoah Jan and the wife, that divorce case. And so, if you would recall, there were a number of issues that came up, the judgment thereof, and some of the things that came up during that ruling. So it is expected. But the guests are seated. They've been here for some time now, and we waited until the members on the committee as well as the chairperson and the rankings came. We see the husband who is here, as well as family to support, and other members from the judiciary who are here to provide some support to the nominee who has been invited as of now to come take her seat, after which the oath will be administered by the clerk to the committee, and right after that the vetting would begin properly, or would commence. And just to bring you a brief profile of Justice Hafisata Amaleboba, she was appointed to the court the Court of Appeal in 2022, and before her tenure on the Court of Appeal, she served as a High Court judge, where she was involved in several high-profile cases, including 7 on the 3-member panel that presided over a famous coup plot case. So that is one that we know about her. We know that her areas of expertise include, family law as well as land law, and also alternative dispute resolution. And there she comes. In your shot, you see Justice Hafisata Amaleboba taking her seat, after which we have the oath administered, and the vetting would commence in due course. And so the clerk to the committee is aiding that process, after which would have her oath administered to her, or she would take the oath. And as a Christian, she's going to use the Bible to undertake that exercise. And so very soon we'll have the vetting commence here. After these two are vetted today, that'll be all, because there were 7 nominees in all. 5 have successfully undertaken their vetting. The remaining 2 are the ones we are dealing with today. And just as the standing orders of Parliament indicate in Order 217, especially when you look at 8, 11 and 12, after all of this is done, it means that the appointment committee would report then to Parliament within 3 days, and then suggest or recommend the approval of or otherwise of these nominees who have been vetted. We now cross over as the vetting begins.
I will then proceed to call on the clerk to administer the oath.
I hereby administer the oath. I, Hafisata Amaleboba, do in the name of the Almighty God swear.
Do in the name of the Almighty God swear.
That the evidence I shall give before this committee that the evidence I shall give before this committee touching the matter in issue shall be the truth, the whole truth, and nothing but the truth. So help me God.
So help me God.
Thank you very much. May I proceed to humbly ask the nominee to tell us briefly about her background.
Thank you, Honorable Chair. I am presently a Justice of the Court of Appeal. I sit on the Koforidua panel, but occasionally I sit in Accra. I started my education at the Jack and Jill School at Roman Ridge in Accra. Very briefly, from there I proceeded to Kotoka Primary School at Bemakam, where I wrote my common entrance examinations. Thereafter, I went to St. Rose's Secondary School, where I sat for my O-level and my A-level examinations. After my A-level examinations, I did my national service at Kanguni Junior Secondary School on the road to Elubo in the Western region. After that, I went to the Faculty of Law, University of Ghana, where I studied law. I also studied sociology and political science. After the University of Ghana, where I obtained an LLB degree, I proceeded to the law school, where I qualified as a lawyer and was called to the bar. After that, I went to the University of Ghana Faculty of Law for my national service as a tutorial or teaching assistant. After that, I went into private practice. I stayed in private practice for 15 years, a little over 15 years. While in private practice, I worked at Jaskin and Associates at the Kotoka International Airport in Accra. I then worked at Piazza Puedo and Company at Gulf House in Accra. Thereafter, I co-founded the law firm Amal Law Consults, also in Accra. After about 15.5 years of private practice, I joined the bench as a High Court judge in 2014. I was in the High Court for 8 years, and then I was promoted to the Court of Appeal. After the Court of Appeal, I have now been nominated to come before this august committee to be approved as a Supreme Court judge. Thank you, Mr. Chair.
Thank you, my lady, the nominee. I will then proceed without wasting my time to open the floor for questions to be posed to you, and you will provide answers to those questions. But kindly be brief in your answers.
Very well, Mr. Chair.
I will call on Bafo Ewa. You have the floor.
Congratulations, my lady, and welcome to the committee. In Justice Samuel Kofi Dateba's book, Reflections on the Supreme Court of Ghana, June 2015, he identifies a problem with the empaneling at the Supreme Court and captures it as follows. The Chief Justice's power to empanel judges confers on him or her arguably the opportunity or potential to influence the outcome of particular cases. The Chief Justice's knowledge of an individual judge's track record on particular issues or his or her judicial inclinations on particular issues may give the Chief Justice this potential. This, rightly or wrongly, has attracted unfavorably, okay, let's end it there, that the knowledge of the Chief Justice about judges can influence, the empaneling. Do you agree with Justice Dateba? If so, why? If you don't, if so, why?
Thank you, Honorable Chair. I believe that in the empaneling of judges, the Chief Justice performs an administrative function. Now, this administrative function is a function that has been given her by the Constitution. And I do not believe that it would or should influence the kind of decisions taken on the bench, because the Supreme Court justices of the bench are experienced, independent-minded jurists who should be able to take independent decisions. Thank you very much, Mr. Chair.
Any follow-up? Thank you. I will proceed to recognize Honorable Boama, Junior Boama.
Thank you very much, Mr. Chairman. My lady, congratulations on your nomination.
Thank you very much.
My lady, you are being elevated to the highest or the apex body in our judicial system, which is the Supreme Court. Can you share with this committee 2 major decisions you've made in your career that you would be remembered for? And can you share with this committee what really the content of those decisions were?
Very well. Very well, Honorable Chair. The first I would mention is that I co-authored a judgment in the treason case, Republic versus McPaul. To the best of my research, this may very well be the first test case under the 1992 Constitution. My checks tell me that there's no appeal pending, but even if there should be an appeal pending, I think that this is a judgment that would chart the path and be a reference for future cases. And also I would like to say that there is another ruling, not a judgment, that I authored in the case Later versus Later. It went to the Supreme Court on appeal, and the Supreme Court reinforced its previous decision in the Ojiadom case, which says that even though an application for stay of execution, even though there can be an application for stay of execution in respect of executable judgments, it is also possible to grant a stay of execution in non-executable judgments, especially so when the execution of that judgment would have executable consequences. So, thank you very much.
Any follow-up?
Mr. Chair, I'll leave it here and then say congratulations once again for your nomination.
Thank you. I will now proceed to give the floor to Honorable Anthony.
Thank you, Mr. Chairman. Welcome, my lady, and congratulations on your nomination.
Thank you very much, Honorable.
My first question, let us look at delays within the administration of justice, within the courts. Could you tell this committee why so many delays with simple land matters? Sometimes some of them travel for 6 years, 7 years, 9 years. Even simple matrimonial matters, 5 years, 6 years. What are some of the reasons you would attribute for these delays?
Thank you very much, Honorable Chair. One of the very first reasons is that we do not have enough manpower to be able to expedite the cases that we have. I would give an example. When I was in the family or divorce court, At a point in time, you could have 300 and over cases, and that's just one court. And that is just one judge who has to determine all these cases. And we should remember that as these cases are being determined, new ones are being filed on a daily basis. So the first thing is lack of manpower or enough judges to be able to expedite these cases. I would also say that another cause for delay is the procedures and processes, especially the interlocutory applications. So many repeated interlocutory applications can stall cases, especially when there's an application before you and you give a decision, and your decision is stayed. It means that you probably, and your decision is taken to the higher court and the case is stayed. It means that you would have to stay your hand until the matter is determined. Another thing is also that we need to be able to look at the procedures, timelines for filing pleadings, from the stage of filing a writ of summons to the stage of filing your pleadings to the application for direction stage. Is it possible to shorten the process so that we can expedite the cases? That is what I'll say for now. Thank you very much.
Now, from your answer on procedure and processes, are you then suggesting that the rules of court are too complex? It's been argued by some people that the rules of court are too complex for ordinary Ghanaians who do not have legal representation. Would you recommend that the rules of court are made very simple, very basic for everybody to understand so as to help expedite the way and manner cases progress in court?
Thank you, Honorable Chair. For me, it's not the complexity of the rules of court, but the timelines may have to be looked at. Because if you have to file a writ of summons and statements of claim, and it will take you about 22 days for the other party to file a defense, we may have to look at it and see if we can shorten the timelines to be able to expedite the filing of pleadings. In that case, we could speedily resolve these disputes. So for me, it's not the complexity, but the timelines. Thank you, Honorable Chair.
My second question, I was trying to do some academic exercise on my own this morning, playing the devil's advocate at the same time. I looked at the CI 47, particularly Order 1, Rule 2. Then I asked myself if all the other orders following after Order 1, Rule 2 help promote the aims and objective of the CI 47 as contained in Order 1, Rule 2. Order 1, Rule 1, 2, yes.
Well, my recollection of Order 1, Rule 1, 2 enjoins the court to ensure that matters are speedily and effectively determined. But since the rules guide the court is guided by the rules in determining these matters. And as I have already said, the Rules of Court Committee may have to look at the timelines for filing of pleadings until when the pleadings are closed and the trial actually starts after applications for direction stage. So I think that timelines may be considered. Thank you, Honorable. Thank you, Honorable.
But my lady, my next question is, don't you think that the problem has to do with post-directions, the procedure where there are no timelines? Is that not where the problem is, where that is subject to the discretion of the court?
Honorable Chair, can I have a clarification of the question? I don't seem to.
But what I'm saying is that after the application for direction stage, there are no clear timelines. Yes, as to when trial should commence. Is that not where the problem is?
We can't have timelines for completing trials. But as I indicated earlier, that would also depend on the number of cases that a court has. Because if a court has 300 cases and 100 of the cases are ripe for trial, definitely some would have to abide other cases. And that is when you are going to have a backlog of cases. So if we are going to have timelines for trial of cases, then we have to address the issue of the number of cases per judge. Then we can give effective timelines for determination of these cases. Thank you, Honorable Chair.
Thank you very much, my lady. My last question, third and last question. Your sister, my lady Janabari, was here yesterday, and as an answer to a question on the activities of the legal aid, she suggested that young lawyers being called to the bar must be made to do some service over there to help reduce the burden on the ordinary Ghanaian who cannot pay for legal service. Do you agree with that?
Thank you, Honorable Chair. I think it's a good suggestion. But I would also say that if the Bar Association does not already do so, the Bar Association should encourage every lawyer to do some amount of pro bono work. I think this will go a long way to assisting with the problem. Thank you, Honorable Chair.
I'm very grateful, my lady. I believe every lawyer does pro bono. The chairman would agree with me. Even in matters where you charge a fee, sometimes when you are done, they refuse to pay. So that's pro bono.
But there is a remedy available for you to recover your fees. You have a remedy under the law to recover your fees. Thank you very much. I will then proceed to give the floor to Alhaji Omar.
Thank you, Chairman. Congratulations, my Lordship, Hafisata Amaleboba. I'm so happy to see you, and looking at your CV and your background, I'm happy because it gives hope to our daughters and our sisters from the region where we come from.
Thank you, Honorable Chair.
My question to you this morning is, what do you hope or want to be remembered for as a justice of the Supreme Court of Ghana?
Thank you, Honorable Chair. I want to be remembered as a hard-working judge, one with integrity, an assiduous judge, and one who sets precedent that will stand the test of time. Thank you, Honorable Chair.
Thank you. The second question, I want to find out from you your belief in the interpretation or the
The doctrine, let me take one. I have some quotes. The doctrine of separation of powers.
Thank you, Honorable Chair. Now, the various arms of government, the executive, the judiciary, the legislature, are all independent. But they have to be interdependent as well to ensure that we have cohesive administration of governance. And so we would have a situation where Parliament would approve the budget of the judiciary. And we have a situation where in the Supreme Court's exercise of its exclusive original jurisdiction, it can have oversight responsibility or review, what is called, informally called the judicial review powers of the Supreme Court, to determine whether Parliament or the executive are acting in accordance with the Constitution. So even though they are independent, they cannot be separate because we are running a governance system. And so they must work together to be cohesive. Thank you, Honorable Chair.
Thank you, and I wish you well.
Thank you very much.
I'll give the floor to Alec Blim.
Thank you, my lord, my lady. Langwane. Great. I saw the name Amaleboba, so no, I'm not sure she's a Fafra. Yeah, thank you and congratulations.
Thank you.
Yes, I went through your CV and I'm interested in the works you did concerning in relation to divorce marriage, because I had my MPhil in marriage and counseling. And once a while, cases come, and most of them, the reason why they want to divorce or separation, they want separation, is lack of commitment from the man. Yesterday, I asked a question with one of the judges. Do you think introducing child support in Ghana would help bring down cases of divorce in our country?
Honorable Chair, may I seek a clarification of the question? Child support as in maintenance?
Yes, maintenance.
Very well.
Because it happens in the other world, yes, after divorce.
Thank you, Honorable Chair. We have child support in Ghana. And so in the court, you can bring an application to the court for maintenance of a child. In fact, under the Matrimonial Causes Act, you can bring a petition for maintenance without bringing a petition for dissolution of marriage. But when you bring a petition for dissolution of marriage, you can also seek orders for child support, which we call maintenance in this country. And the court will consider it. The court will consider the best interest of the child and make an award looking at the circumstances of the case and the means of the person involved. So we do have child support in Ghana. Thank you, Honorable Chair.
Thank you, Mr. Chair. My second question, can you take us through the process of adoption in Ghana? Because once in a while, just as I said, I have issues coming up where couples have been married for some time now and there are no issues, and they don't know the process of getting adoption in Ghana especially.
So, Honorable Akurugu, you don't want the bar to prosper. The bar must prosper. My lady, you may proceed to answer.
Thank you very much, Honorable Chair. The process of adoption starts from the Social Welfare Department. First of all, you must contact the Social Welfare Department, and then they would assess your needs, the kind of child you want, and then see if they have children available, and they would make the necessary recommendation. Now, when the application is brought to the court, the court would look at the application, the court would look at the circumstances of the child and decide whether it is in the best interest of the child that the adoption be granted. But now we have a central adoption agency, just so that adoptions can be streamlined to meet international standards. And so the central adoption agency, which ordinarily is under the supervision of the ministry, would ordinarily approve for you to adopt the child. And then you bring an application to the court. And the court would look at the application and decide. The fact that the Central Adoption Agency has approved does not necessarily mean that the court would approve. The court, if it approves, will grant the application for adoption.
That's for it, Mr. Chair. Congratulations once again.
Thank you very much.
Wishing you all the best.
Thank you.
Well, I proceed to recognize Honorable Tambuli.
Thank you very much, Mr. Chair. Mr. Chairman, the gentleman sitting behind the nominee, Mr. Peter, is my very good friend. So I'm thinking if I even ask a question, I will be asking him indirectly. Nevertheless, my lady, I congratulate you on your nomination.
Thank you very much.
There is something that I've noticed about the judiciary, especially Superior Court judges, which is the fact that you have a number of judges being chiefs in addition to being judges. Now, under the 1992 Constitution, and if you read Article 78(1) and Article 93(3)(c) together, tells us that members of parliament cannot be chiefs. Similarly, ministers of state can equally not be chiefs. Why should
you become a politician and you want to become a chief, it would seem to me that the institution would be politicized. That probably is the reason why the Constitution does not permit. Thank you, Honorable Chair.
Mr. Follow-up. My lady, will your answer be different if you find instances where chiefs who are also judges meet political heads, candidates, and they start talking, yes, we are with you, we'll make sure you win, and so on and so forth. Appearing before that judge, will that sense of neutrality still be there? I mean, the cloak would have been taken off him for the comments, some of these comments. Meanwhile, maybe the chief probably is just looking for development for his people, but his comments, may be taken as a very weighty matter, which would take him to the side of politics and remove the neutrality cover.
Thank you, Honorable Chair. I believe that as a judge and a chief, you ought to be measured in your commentary on politics, especially in support of one group or the other. So I believe that the judges are able or should be able to be measured in their language. Thank you very much.
It's now the turn of Honorable Fajala Diayamba.
Thank you, Chairman. My sister Amaleboba, well done, you've done well.
Thank you very much.
There is the issue of whether or not to cap the number of Supreme Court judges. Currently, according to information, we have 13. If 7 of you go in, and inshallah you will be 20. What is your suggestion about the numbers? Should we add up, just leave the law like that, continue to add up, or we should cap it?
Thank you, Honorable Chair. I believe in capping the number of Supreme Court judges, but I believe that we should not hasten to do so until we have resolved the issues that confront the Supreme Court, which require that the numbers be increased. Because if we cap it and there's a justification for an increase, it would mean that we would subject our Constitution to constant amendments, and that will not be desirable. But if we are able to solve the problems at the Supreme Court, the backlogs, the various jurisdictions that it has, then we would have a fair idea of how many cases on a year-by-year basis would go to the Supreme Court. And then we can have enough reason or basis to cap the numbers. Thank you, Honorable Chair.
Chairman, my second question. My second question has to do with the establishment of regional tribunals, and that is Article 142 of our Constitution. And when you look at it, the membership shall consist of the Chief Justice, one chairman, and such members who may or may not be lawyers. Do you subscribe to our having regional tribunals? And if the Chief Justice is supposed to be part of the panel there or the team there that is going to work, how do we get enough of such people at any given time so that it shouldn't be like, oh, the Chief Justice hasn't come, so we do not know what to do. Let us postpone the case, let us hold on, and maybe when she's ready or when he's ready, then the case will be heard, where our cases will be prolonged.
Thank you very much, Honorable Chair. I do not know the policy rationale for why the tribunals, the regional tribunals, were abolished, so to speak, or were subsumed into the regular court system. But it still remains part of our law. And the law says that it is the duty of the Chief Justice to establish regional tribunals, and the duty of Parliament to prescribe exactly what their jurisdiction should be in respect of state matters and public interest matters. And so, insofar as the regional tribunals still remain part of our laws, I do not have any aversion to regional tribunals. I would also like to say that the Chief Justice is a judge of every court in Ghana. The Chief Justice is the first judge of every court in Ghana, but she does not sit when it's empaneled, even though she can decide to sit. So ordinarily, a 3-member tribunal doing its work would not require the presence of the Chief Justice to sit. Thank you, Honorable Chair.
Thank you, Chairman. I'm most grateful. I wish you all the best.
Thank you very much.
Thank you. I'll give the floor to Honorable Bid Sidin Awandazuma.
Thank you very much, Honorable Chairman. Your leadership, congratulations for the nomination.
Thank you very much, Honorable Chair.
And let me tell you that we, the Upper Westerners, we are very proud of you.
Thank you.
I made this statement when His Lordship Sulbare appeared before us, and I indicated that we are happy to have 2 Supreme Court judges coming from the Upper West region, because you will be approved. And we are further proud of you because we have the first lady Chief Justice also coming from Upper West. We hope that in course of time, our colleagues in the other northern regions will also benefit from this exercise. Anyway, ordinarily, I should not be asking you any questions, but I'll just ask you one question. But even before the question,
some small comment. You are a Christian, but it's surprising that your first name appears to be a Muslim name. I'm curious about that. I will not expect any response from you, but it is interesting that you are a Christian and yet you have a Muslim name. I believe that the second name is your husband's name, and your husband must be one of our playmates. So it is all good. The chairman, you are not happy the way you are looking at me.
Yes, because you have to ask questions.
Yes. I'm coming.
You are not to run a commentary. And you know you are violating the rules of the House.
Sometimes.
So you don't expect me to be happy when you are violating the rules.
Thank you very much, Mr. Chairman. The question is, the retiring age of public servants in this country is 60. Sometimes it is extended to 60, a maximum of 65, 61, 62, 63, but maximum of 65. But justices of the Supreme Court, they retire at 70. So it appears there is some discrimination because these categories of people are all serving the Republic. Your leadership, in your view, is there justification for the difference? Other public servants retire at 65 maximum. Judges retire at 70. Is there any justification for this difference? Thank you.
Thank you, Honorable Chair. The justification that I see is that in the administration of justice, we need qualified, experienced jurists to be able to adjudicate matters that will stand the test of time, and to be able to also guide relatively younger judges on how to proceed. So we need experienced jurists in the Supreme Court, because that is our final appellate court. It is also our constitutional court, and it has various other jurisdictions. So I believe that the age is important because of the experience and qualifications that the jurists would have gathered over the years. Thank you very much, Honorable Chair.
Mr. Chairman, that will be all for now. Thank you. And I wish you very well.
Thank you very much, Honorable Pete. Yes, Patrick Yawoma.
Thank you, Chairman, and congratulations, my lady. Thank you. My lady, I've gone to your CV, and I've realized that you've chaired quite a number of committees aimed at reforming the judiciary, or the judicial service. Committee to investigate allegations of procurement of fraudulent divorce certificates and other court documents, 2023. Committee for setting up attestation units in other regions and for digitalization of the said units, 2023. Committee for implementation of recommendations made by the committee to investigate allegations of procurement of fraudulent divorce certificates and other documents, 2024 to date, and a host of other committees. I would want to know from you how the implementation process has gone on with regards to some of these committees that you've chaired, and remedies they seek to achieve in advancing our judicial process and also promoting the integrity of the courts. Thank you.
Thank you very much, Honorable Chair. In respect of the procurement of fraudulent documents, and the attestation units. These two are linked. So it is the aim of the Judicial Service to ensure that people do not procure fraudulent divorce certificates and documents and parade them as coming from within the Judicial Service. So what has happened so far is that we intend to start a process. We are just at the implementation stage. We intend to start a process of ensuring that divorce certificates have special features, and that special seals are given to judges, and also electronic signatures are used for these documents. We also intend to ensure that each certificate would have a barcode, so that if you have a smartphone, you can scan the code, and that will tell you whether or not the certificate or the document is coming from within the Judicial Service. Now, with the attestation units, we are yet to start work on the attestation units. And the intention is to digitalize the attestation units to ensure that all attestations are done through a system electronically, so that we take out the manual attestations, which can be forged by people outside of the service. But if we have all of them passing through the system, then it's easy to track and ensure that we don't have forged documents out there. But with the attestation unit, what has started happening is that if you take a document to the attestation unit for attestation, your ID card would be taken and a photocopy would be made of it. Now, and documented, if it is realized that the document is a forged document, you will be reported to the police and you will be arrested. So that is how we have started working in respect of these committees. Thank you very much.
Chair, and a follow-up, and are you receiving the needed funding to ensure the actualization of this project, and from where?
We have not yet requested for the funding. For now, the attestation unit is using the resources it has at its disposal to ensure that this is done. But we will get to that stage where all of the various departments involved will come together, the budgets will be drawn, and then the necessary things will be done. Thank you very much.
When I go to my second question, my lady, after this question, I'll let you advise those of us around the table. We politicians, those of us here, we tend to play politics with a lot of things. When it comes to the appointment of judges, independent constitutional officers, we talk a lot. You read our Hansard, the debate, so partisan in nature. In 2022, you got the opportunity to be nominated to sit on the Court of Appeal. Some justices sat at the High Court, straight to Supreme Court. Some 1 year at the Court of Appeal, straight to Supreme Court. Some became Chief Justices and what have you. I believe when you go to the Court of Appeal, you met some senior members too there, and by God's grace, gotten the opportunity to be nominated. What would be your advice to those of us around the table that nominations are not political, are based on certain steps or considerations? And that's one of the reasons why you are before us. So what do you have to say to some of this? You see you politicians.
Honorable Chair, I would pray to let the cup of advising the politicians pass from me. But what I would say is that, indeed, I met some judges at the Court of Appeal, and I have a lot of respect for my esteemed colleagues on the Court of Appeal bench. Nominating a judge for the position of the Supreme Court is the prerogative of the President. And the President has done so. And I believe that I'm qualified. I have spent 15.5 years in private practice. I've spent 11 years on the bench. I'm 26 years at the bar. I am qualified in accordance with the constitutional requirements. I'm capable, I'm competent, and able to discharge the duties of a Supreme Court judge. Thank you, Honorable Chair.
Thank you very much, my lady. And I know you distinguish yourself and put to rest some of the debates some of our colleagues wage. My lady, can we look at the rules of fair trial, I think Article 19. It deals with a lot of issues when it comes to fair trial and what an accused person ought to be, the opportunities that accused person ought to be given, right to counsel, facilities, what have you. And reading that in conjunction with I think Section 967 of Act 30 on bail. Sometimes bail conditions are a bit too onerous that a layperson can easily say that this will amount to being denying the person bail or it amounting to punishing the accused person. It's a discretion given the judge, given the circumstances or the facts before the judge. How would you explain some of these factors to the listening public as to what goes into the grant or some of the bail conditions that you give to accused persons, in order not for the public to think the accused person is being punished or being denied bail? Because I recall some comments by the late Justice Badigbe that some of the conditions may amount to punishing the accused person. I want to hear your thoughts on the rules of fair trial and bail conditions, which some of us deem too onerous in our opinions. Thank you.
Thank you very much, Honorable Chair. Well, the position of the law is that all offenses now are bailable. And if an accused person is granted bail conditions, which he or she deems are onerous, you have the liberty to apply for a variation of your bail conditions. And if you find a stumbling block in that court, you can appeal against those conditions. Because the aim of the conditions is not to punish the person, but to ensure that you will make yourself available for trial. And that at the end of the day, if you should abscond, the sureties who have signed your bond would be able to meet whatever conditions are required of them. And so it is not supposed to be a punishment. So if you are unable to secure bail or the conditions are onerous, you either apply for a variation or you appeal so that the appellate court can take another look at it. Thank you very much, Honorable Chair.
Thank you, my lady. It will surprise you that you appear before a judge and the mood of the judge will be that, oh, yes, I've refused your application, you can go up. straight away. And without considering the merits of the application, so, okay, I've read and I'm refusing, you can go out. And you can easily tell from the court that the person wasn't minded to even listen to you or take into account the conditions that the judge was setting. And it becomes problematic because I was in court one day, the accused person had served his term, it was left with only 3 months, and the lawyer was making an application for for a variation of a certain order that the judge had made. So, oh, no, I'm refusing it. You can go on appeal. The person was left with only 3 months, and it was within the judge's remit to consider the application before her. And it became some banter between the lawyer and the judge in open court. And those are some of the things that I believe that when you go for training, you can look into some of this. The temperament at the bench sometimes makes lawyers exchange, for want of a better word. Thank you very much, my lady.
Thank you very much, Honorable Chair. I believe that the JTI would take that into consideration and ensure that the appropriate training is done. Thank you.
My lady, on that note, I wish you the very best. God bless you.
Thank you very much. Honorable Jerry, you have the floor.
Thank you very much, Honorable Chair. Honorable Nominee, congratulations on your welcome. Lady, you've been in this practice for 26 years, and you've dealt largely with issues of dissolution of marriages. Lady, family law cases increasingly involve complex constitutional questions regarding gender equality, children's rights, and traditional versus modern family structures. Given your very extensive experience in family law, how do you view the Supreme Court's role in balancing traditional family structures with evolving constitutional principles of gender equality?
Honorable Chair, can the question be clarified?
The question is seeking to know how you intend to use your background as an expert in family law to deal with issues of constitutional matters, especially people are now making more or concentrating their attention on gender equality. How do you marry the two? How are you bringing your rich experience on family law to deal with issues of gender equality?
Thank you, Honorable Chair. And when it comes to family law, the principles are applicable equally to men as it does to women. Because when it comes to distribution of marital property, it is not based on gender, even though it may seem so. It may seem so, but the law is not based on gender. Because it says, Article 22 says that assets acquired jointly during marriage are to be distributed equitably. And whether, irrespective of their gender, that is what the provision is. So it is not in any way discriminatory of any gender. That is my answer to the question.
Just a follow-up. Have you handled cases where the man seemed not to have properties, but the woman seemed to have properties, but they had these properties during the currency of the marriage, and then when it came to distribution, there were issues because the man was now requesting that the properties be shared equally?
I do recall that there was a case before me where the man did not have properties, but the woman did. And I gave the man part of the woman's properties. The man did not have properties, but the woman had properties. And the man was entitled to a share in the woman's properties. And that is exactly what I did. Thank you very much.
Thank you very much, Lady. The Supreme Court frequently addresses cases involving children's welfare that require balancing parental rights, state intervention, and the best interest of the child. Lady, how can the Supreme Court interpret constitutional provisions regarding children's rights when they conflict with this parental authority or cultural practices?
Thank you, Honorable Chair. The law is clear that in every matter affecting children, the welfare of the child is the court's primary consideration. So in all matters affecting children, it is the welfare of the child that is the primary consideration. So that is what the law says, and that is what is applied in the courts. Thank you, Honorable Chair.
Lady, have you had the occasion of dealing with a matter that the welfare of the child, although very key, the Constitution perhaps also had a position, and therefore you felt a bit conflicted, especially as a mother?
Can I have a clarification of the constitutional conflicts? I'm not too clear on the conflicts. Thank you.
Well, maybe there was a set like that, you just give a response, and then there was the basis for you to proceed to say that, well, the law is the law, and so I need to proceed to give a judgment or make a decision or a determination based on the law. But you also felt that at this point in time, maybe you could have considered the child's welfare more, but it's still conflicted with the law, and therefore you proceeded to deal with the matter the way you had to deal with based on the law.
What I said was this, that where a child's welfare is in conflict with a parental authority, you said, then in that case, the child's welfare will be considered. Because in considering the child's welfare, you must find out whether or not what the parent seeks to, the authority the parent seeks to exercise is in conflict with the rights of the child. And if it is in conflict with the rights of the child, then you need to prioritize the welfare of the child. That was what my explanation was.
Well, I think it's well understood. Lady, this will be my last question, is how do you envision the Supreme Court's role in developing constitutional standards for ADR, alternative dispute resolution mechanism?
Thank you very much, Honorable Chair. The ADR Act is the standard for resolution of disputes by either mediation or arbitration. And I believe that this is what is enforceable, even in the Supreme Court. If the matter should probably go to the Supreme Court, but not on the merits, because you cannot appeal against an arbitral award, for instance. You can only seek to set it aside on procedural or other grounds, but not on its merits. There's no appeal in respect of that.
Are there any recommendations you would want to make in reference to ADR, the ADR mechanism?
Not immediate. I can't think of any immediately.
Very well, my lady. I wish you all the best and congratulations once again.
You're done, Honorable Chair. All right, I will now call on Honorable Lefiamapo. You have the floor, Chief Whip.
Mr. Chairman, thank you very much. My lady JS is soon to be. You're welcome and congratulations. During our formative years at the bar, you were one of the few lawyers that anytime you step into court, we had to wait to listen to you. And then when you got elevated onto the bench, we had a tough time before you. So you didn't get here by accident. You merited it. And I'm very proud of what you have achieved so far.
Thank you, Honorable Chair.
I have two questions by way of policy, and so I'll zoom straight into the first one. One of the jurisdictions of the Supreme Court, by way of appellate jurisdiction, is to hear matters emanating from the National House of Chiefs when an aggrieved party, after exhausting the procedure, then proceeds to the Supreme Court. Now, in Articles 270, 271, and 273, speaks of the Chieftaincy institution and the National House of Chiefs and the Regional House of Chiefs. Now, in the Constitution, there's a provision for lawyers to assist the judicial committees when they are determining chieftaincy issues. The National House is to be assisted by a lawyer of not less than 10 years. The regional ones, a lawyer of not less than 5 years. We didn't make any such provision for the traditional councils, the Judicial Committee of the traditional councils, but we borrowed the spirit and letter of the Constitution, inserted it in the Chieftaincy Act. But the arrangement creates a problem because, I'll set the question as a background. The matters that eventually will come before you at the Supreme Court emanates from the judicial committees of the traditional councils. And then we ask lawyers of less than a year, or not at least 1 year, to assist them. So where error occurs, it then travels all the way to you up there. I know it's this house that must make amends. So will you support a proposal that instead of the lawyers assisting, they are made to participate in the proceedings by being part of the panel instead of being made to assist? And because in most cases, I've done, by way of work, done some chieftaincy cases, and the traditional councils don't have money to hire lawyers. So it's the chiefs who go on and handle the matters, riddle with errors. It gets to the region. Some too don't have resources to engage lawyers. So it's the national that really have some lawyers assisting, by which time the damage would have been done.
Thank you, Honorable Chair. I believe it's a laudable suggestion and one that I would support. And invariably, it would also reduce the workload at the Supreme Court. Thank you very much.
Great. My other concern is in respect of the matters containing Article 153 and 154, the Judicial Council.
Sorry, leader. Is this a follow-up or is it a new question?
Chair, I was very clear that I have two questions.
Yeah.
The first one is done. Okay. So the second one is in respect of the Judicial Council, creature of the Constitution.
Go ahead.
If you look at the composition presently, a very key stakeholder in the justice administration and delivery channel is not included, which is the Ghana Prison Service. Again, would you support the proposition that we should have a representation of the Ghana Prison Service as part of the constitutional amendments represented on the Judicial Council?
Thank you very much, Honorable Chair.
Especially in view of your functions, in view of the functions that the Judicial Council performs.
Thank you very much, Honorable Chair. I believe it's a good proposal because it would seem to me that the prison service is an important stakeholder in the administration of justice. Thank you.
Chairman, thank you. Let me once more congratulate you, and we wish you all the best. And we'll look forward to appearing before you in the future.
Thank you very much.
Congratulations.
Thank you.
Thank you very much. It's the turn of Honorable Patricia PJ. You are Deputy Ranking. You are on the floor.
Thank you very much, Mr. Chair. Mr. Chair, I'd like to take this opportunity to congratulate Darlene. And I'm actually ceding my time in order for you to live here. And I'm ceding my time to the minority leader to go through. Thank you very much.
Thank you, Honorable Chair.
Thank you very much. I will now cede the floor to Osahini, the ranking member. Thank you.
Thank you, Chairman.
Please go ahead. Please go ahead.
Chairman,
please go ahead.
I just heard that you are going to call the majority leader after I'm done for re-examination. Then you call him. He as a leader is entitled to be here. Call him. The practice and the protocols which he knows is that I'm the last. I'm your ranking. I'm the last to ask. So if he wants to ask, let's allow him to ask his questions.
Honorable ranking member, at the moment, I am the chairman of this committee, and I'm the last person to speak. So I indicate who speaks next. You are on the floor. Thank you.
All right. At least what you just said has become part of our records. A good precedent, no problem. When I'm done, just call the majority leader to do his re-examination, no problem. Honorable nominee, we did some checks based on your own CV you brought to us. I want you to clarify for the record. Where did you do your national service?
I did my national service after A level at Kangbili JSS, Kangbili Junior Secondary School, in the Western region.
Very well. My lady, please, in your time after doing your national service, are you issued a certificate during those periods? Were you being issued with certificates?
I did not get a certificate. I did not get a certificate when I finished. I am sure I could have applied for a certificate, but I did not get a certificate. Yes.
The the reason I ask you in all fairness is because national security got back to us that they have no such records of you having done your national service at Kangunli JHS in Western Region. That's why I wanted you to clarify, because
I did.
Very well. So you may have to furnish us with some other details you have later, not now, just to confirm. All right. Now, what is your age now, please?
I'm 52 years old. 52 years old.
Very well. So what it means is that if the opportunity avails itself, you would have some 18 years to serve on the bench.
That's it.
My lady, I intend to take your thoughts on Articles 286 and 287 of the Constitution. I would preamble what I'm going to say. With recent decisions of His Excellency the President regarding imposition of salary fines on ministers and appointees who fail to declare their assets, I shall also want to know your mind on the exclusive role of SHRAJ in investigating breaches of asset declaration obligations. That said, as a background, I proceed to ask you, one, in your view, do you think that the President has a constitutional authority to impose sanctions, such as fines on ministers and other appointees who fail to declare their assets? Or, to you, this function is exclusively reserved for SHRAJ under Article 287 of the Constitution?
I believe that the Office of the President has decided to put in place some administrative procedures. And I do not see that there is a conflict with the duties of SHRAJ. Because if a public officer is reported to SHRAJ as having contravened the law on filing of the necessary documents or declaring assets, SHRAJ would also be entitled to take its necessary action. So I do not think that there is a conflict between the two.
My lady, that said, let's stay a bit on what you describe as the administrative decision. So that is at the heart of my question. Are you therefore suggesting that in spite of that constitutional mandate given to SHRAJ to investigate and make appropriate orders or recommendations, sanctions, etc., administratively, the President, in the exercise of his executive functions, can also impose sanctions, fines, as is the case?
Honorable Chair, I would like the question to be repeated.
So, what I'm saying is that the Constitution mandates SHRAJ to take up matters regarding breaches of the Constitution in the manner that I've already given a background to. And I'm giving you an example of asset declaration. Failure to failure to declare your assets. I am referring to the recent administrative directive by the President to sanction those breaches by way of a fine. In that context, I want to pick your thoughts on whether or not administratively His Excellency can usurp such powers to impose administrative fines as part of his executive powers.
Thank you, Honorable Chair. I do not think that it's a usurpation of powers. That is my position.
Very well. But administratively, Chairman, this strategy by the majority that they have their time, when it gets to my time, then I have follow-up. Anyway, I will yield to you. If you, Chairman, would want to allow these things, no problem. Follow up and think that you will be distracting me. I don't.
Honourable members, I believe everybody must be treated equally, particularly the leaders. There are instances where the minority leader called for a follow-up question and has been granted the floor to ask a follow-up question. In all the vetting that we've carried out, the record can bear me out. So if the majority leader wants a follow-up question, I think it is in good faith that we ask him to do a follow-up question. Please, majority leader, you have the floor.
Well, this being the first time I'm speaking, let me join colleagues to congratulate my 1 year.
Mr. Chairman, let's be careful what we are doing. It's not good for democracy. If it's a follow-up, let me congratulate my 1 year. If it's a follow-up, you should go straight to the Chairman. Don't be doing these things. So it may be politically convenient for you, but tomorrow it will hit us as a parliament.
I can just understand the minority leader this afternoon, because if the person going to ask the follow-up question is now talking to the nominee for the first time, what is wrong?
But he would have the opportunity to ask his own substantive questions. So he's already indicated to the deputy chair that he will take his turn after me. Please, let us not set a bad precedent. This is not the first time we are doing vetting. Let's stop this. You are the majority. You may not want to delve deeper. Allow us to do our work. What is happening is not good, Mr. Chairman. When we talk, it's like we are sharing your power. Let's stop it. It's not good for the country. It's not good for our image as parliament. And I protest. He says he's going to have his 10.
Honourable members, I do not think any rules of the House has been flouted. So I'll proceed to give the floor to the majority leader. Majority leader, you have the floor.
Thank you very much. Let me join some colleagues to congratulate my 1 year senior at the bar on your nomination to the Supreme Court. By way of follow-up question to what he has done, if a president appoints ministers and public officers and directs all of them to file their asset declaration forms with the Auditor General, and then further directs that when they have filed, they should send him the receipt. Because when you file with the Auditor General, they issue with a receipt. And he further directs that when you file, forward a copy of the receipt to me so that I see that you have actually filed. If you don't send me a copy of the receipt, I will sanction you. If the president sanctions his appointees for not forwarding copies of the receipts to him, how is that, in your opinion, a usurpation of the functions of the Human Rights Commission?
Honorable Nominee, you have the floor.
Honorable Chair, it is to me not a usurpation of the functions, and I have said so. Thank you.
Yes, Honorable Minority Leader, you may proceed.
Honorable Nominee, now let me be very specific and pick your thoughts. General sanctions imposed by the President against his appointees for some stated misconduct, in my view, may be within his general powers as an executive president. However, my question to you is, would the president be acting within his constitutional powers, having in mind Article 287 of the Constitution, if he imposes salary fines on his appointees for failure to declare their assets, to impose salary fines?
Honorable Chair, as stated, I do not see that the President has usurped his powers. It is an administrative fine or sanction that he has imposed, and I think it is well within his rights.
To impose salary fines, correct? I mean salary fines. That was your general. I'm referring to the salary fines, the imposition of salary fines. That is the one I'm talking about. As for the general issue of not usurping the powers of Shraj, I've understood you, that he has the powers to administratively sanction. But I'm saying specifically on imposition of salary fines. Your thought on that?
The nominee has heard your question and has provided an answer. So,
Mr. Chairman, yes, he's provided. I've heard the nominee on the issue of usurpation, and I'm not litigating that. What I am specifically narrowing on, which I want unambiguous view. She can say she's abstaining. Yesterday, some declined to answer. I won't pursue. I am asking whether specifically the power to impose salary fines, do you consider that to be constitutional? That is my specific question.
Honorable Chair, my position remains the same.
Very well. Very well. Very well. We move on. Now, my lady, how should the court view presidential actions that appear to preempt or substitute investigative and enforcement role constitutionally vested in Shraj under Article 287?
Can the question be clarified?
My lady, by way of clarification, and I would repeat the question and break it down so that I assist with some example to help. And I thank you for always seeking clarification. So the question is, how should the court view presidential actions that appear to preempt or substitute the investigative and enforcement role constitutionally vested in Shraj? So instances, now you're going to that all-important court, the Supreme Court. a matter comes before you and on the face of the facts, you realize that there is a preemption, or the presidency or the executive has taken certain decisions that in itself takes away the powers of a constitutional body. As a court, having seen such a situation, what would be the reaction of the court? That is the point I want to know.
Honorable Chair, I believe that these matters will be determined based upon the evidence before the court and the issue placed before the court. So it's very difficult to make a general statement of how the court would react. So it would be dependent on the circumstances of each particular case. Thank you, Honorable Chair.
My lady, will the courts readily and boldly intervene upon clear breaches in such circumstances based on the facts?
If the court should come to a conclusion that there is a clear breach, then I believe and presume that the court would act. If the court should come to that conclusion, then the court would take an action. Yes.
Very well. Let's deal with a bit of rule of law and accountability. In your view, what do you think would be the accompanying risk of allowing a certain president to set the punishment for non-declaration of assets, particularly in the absence of an independent investigation or an independent body constituted for that purpose? What do you think are the constitutional risks?
Honorable Minority Leader, is it not the same question that you are coming back to ask? Same question has been asked and answers provided. So for me, it is the same question that you are rephrasing. So may I answer? You may ask another question, please.
Chairman, if you want to find a way to stop this vetting, I will yield to you. Stop what you are doing. The whole country is watching you. Stop what you are doing. Stop what you are doing. If you want us to fold up, I'm not here to debate with you. I'll fold, discharge her, let us go. If that's what you want to achieve, I've seen it all. This drama, but whatever precedent, if not 4 years, 12 years, 20 years, it will come back and haunt this house. No problem. If you are strategically planning that a Supreme Court nominee should not go through this thing, so be it. But this question is not out of order. I am putting a question. Please pay attention to my question. Pay attention to my question. Pay attention to the question I'm asking. I'm not asking the same question. I've done research, I've worked overnight. I left this parliament, my office at 12 a.m. Go back here at 6. I know what I am asking. I'm not saying the same thing. For the avoidance of doubt, I repeat my question. What are the constitutional risks?
I have a short response to
Please respond.
Said. The public is not only watching me, it's watching all of us. And the jury will be out there. I cannot be intimidated by you. I'm a man with indomitable spirit. I still rule that a question has been asked. The nominee will not answer this question again. Pose another question.
Honorable nominee, the executive has its executive powers provided for in the Constitution. What, in your view, will amount to situations where risks are created by allowing the executive to overreach its constitutional mandate with administrative directives.
Thank you, Honorable Chair. A determination that the executive has overreached its mandate will be made when the matter comes up before the court. And if the court comes to a determination that the powers have been exercised in contravention of the mandates under the Constitution, the necessary orders would be made. Thank you.
My lady, in your view, if you are confronted with a requirement to use administrative directive of convenience to solve a problem that emanates from a constitutional breach and a requirement for due process to resolve, say, what will be your option?
Yes, Honorable Chair. In all cases where it is established that an action is a breach, then it would be important to proceed along constitutional processes.
Now, let's delve a bit into the nature of asset declaration and obligations thereto. Do you consider the failure of declared asset under Article 286 to be an administrative lapse or a potential breach of the Constitution requiring formal investigation and sanctions through SHRAJ?
Honorable Chair, I believe that SHRAJ has its procedures for determination of sanctions in respect of breaches of declaring assets. So I believe that whatever it deems appropriate, that is the procedure that will be applied. Thank you.
Very well. But do you think that under Article 286, let's go to Article 286. It's important we delve a bit into this. First of all, have the opportunity to read. I'll give you the opportunity to go through 286. Then when you're ready, I can ask the relevant question. When you're ready, please raise your hand to prompt me, please.
We can proceed. We can proceed, Honorable Chair.
My lady, upon full reading of 286, what conclusions do you come there to?
The conclusion I come to is that public officers are enjoined to declare their assets. And where there is a demand for same to be produced, it ought to be produced. That is the conclusion.
Very well. So, my lady, you would agree with me that the Constitution does not create a sanction regime for any breaches thereto, correct? You would agree with me on that?
That is correct.
That being the case, I now would want to ask you that such a lapse that you have identified, what would be your suggestion by way of a cure? Do you suggest, are you of the school of thought that holds a view that in the absence of a clear sanction regime, this should be cured through an administrative directive, or it should be through the Constitution itself?
Honorable Chair, as has been stated, that there's no punishment regime, then what it would mean is that there's a lacuna in the law, and that must be addressed.
My lady, there's a lacuna in the law, and that must be addressed. I agree with you, but just to avoid ambiguity, that lacuna, would you suggest a constitutional pathway to addressing same, or an executive administrative directive?
I believe the solution would lie in having a comprehensive discussion or deliberation on how to proceed to address this.
My Lord, may you expatiate a bit? I'm a bit at a loss, please.
Yes. What I have said is that it would need some deliberation on how this should proceed. For instance, presently we have the Constitutional Review Committee sitting. So if proposals are made to it on how to proceed, it can compile these proposals for the necessary action to be taken. So that is my position.
Very well. I agree that that is one approach. What about the court itself taking the matter up to provide the guideline? Would you think that option also suffices?
That option can only be considered when the matter is before the court.
Obviously.
And so the matter comes before the court. One cannot say whether it will be a case where constitutional interpretation address this lacuna. So until the matter comes